Hey Melissa, can you hear me? Or Miss Bridgewater? Question. Earlier today, we had a client who had a vehicular and had to go before Judge Wolf. So are they going to stay in Superior Court or are they coming back down to State Court? Do you know?
Usually when they have court in different, they have hearing in different courts, they will probably more than likely bring them here or put on the link so that they won't.
No, no, I got you. So let me just help clarify. They got arrested
It's
on
still a misdemeanor, but they just have
right,
to be heard over there for
but
that
but it's going
charge.
to stay in State Court though. It's not
Yes.
going to. Okay, cool. Thank you, Tusa. Thank you, Miss Bridgewater.
You're welcome.
Good afternoon, everyone. Hope everyone's doing well this afternoon.
Good afternoon, Your Honor.
Afternoon, Miss Bridgewater. The SAP reset date?
Is April 8th.
Thank you.
April 8th. Got it.
Good afternoon, everyone in courtroom 2. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. We're providing you with the assistance of a public defender this afternoon if you do not have a private attorney and choose to utilize the public defender services. It is right before 2. Let's see, who do we have first?
I think Taylor Connor, I believe.
It is number 3.
Okay,
And that's going to be my client, Your Honor, Rashid Morel with the Public Defender's Office.
yes, good afternoon. Good afternoon, Mr. Connor. I'm Judge Eric Morrow. You've been charged in case 25 CR 0011551E with simple battery family violence. Good afternoon, Mr. Howard. Is there history?
Hey, this is our third arrest. 2019 trespass dismissed. 2019 contraband arrest.
Thank you. Good afternoon, Ms. Najiza.
Good afternoon, Your Honor. How are you?
I'm doing well. Hope you are as well.
Thank you. Yes, Your Honor. On March 24, 2025, officers responded to 2798 Peak Road Northwest, Atlanta, Georgia, 30318. In regards to a dispute, Ms. Taylor Connor is the defendant in this case, and Ms. Aquinita Wilson is the victim. David Moore, who's the defendant's boyfriend, told the officers that he was outside the home when he heard a dispute coming from inside. When he went inside, the victim and the defendant were fighting. He attempted to break up the fight by getting in between them. The officers also spoke with Miss Wilson, the victim. She stated that when she came home from work, the defendant confronted Miss Wilson about something she said on the phone earlier that day. The defendant then pushed Miss Wilson. According to the defendant, the victim was calling her names, and she was throwing items at her. Mr. Moore intervened. The victim in this case is the mother of Mr. Moore's child, and the defendant is the girlfriend. They all live together in the same household. The state recommendation is a $1,000 signature bond through pretrial, no violent contact with Juanita Wilson, not drugs, alcohol, or weapons while on bond. We did speak with the victim. She stated that she's not afraid of the defendant, that they do live together in this location, and she confirmed the events in the warrant. Ms. Wilson stated that she'll be on Zoom if we can sound for her in case she wishes to speak.
And I saw Miss Wilson on it. She's on here.
I see her. Yes, Ms. Wilson, if
Yes.
you choose to, if
Yes,
you'd like
I'm
to
here.
address the court this afternoon, good afternoon, ma'am. If you can raise your right hand for me.
Hello.
Hello, ma'am. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, yeah, thank you, ma'am. You can place your hand down. What would you like to tell the court?
Okay. Well, I'm Aquanita Wilson, and I got home from work. I came in my room, changed my clothes. I went in the kitchen to make me something to eat. That's when Taylor approached me in the kitchen and said, "What was that stuff you was saying while you was at work?" I told her, "Take, back up. I'm just trying to make me something to eat." She didn't listen. She kept getting in my face, and she walked off. She goes into the room, and then here come my mom. My mom comes. I call my mom on the phone, and she
Your
gets
Honor, may I object to this going into the details, but if we can just kind of limit her to, fairness, et cetera, release, et cetera, just because I didn't want to, be able to cross-examine and all these other kind of things.
Okay, well, if you've been in my courtroom before, Mr. Merrill, you know that I allow especially alleged victims to tell me whatever they want to tell me. So I'll give you the opportunity to tell me anything that you want to tell me as well. But my practice is that I will hear them until until I'm satisfied. Okay. So Ms. Wilson, thank you, sir. So Ms. Wilson, if you'll come back on video for me. Are you
Yes,
there, Ms.
sir.
Wilson?
Yes.
Okay, you
Cut
can
off.
continue. What else would you like to tell me?
Okay, I just make a long story short. We got into an altercation. She started doing stuff. I stopped doing stuff. Then that's when my baby dad's mom come upstairs. They start arguing. They go back and forth. She's still throwing stuff. Next thing you know, leads to us all fighting into the room. She's on the floor. She get knocked into the room. I hit her. She hit me. My mom hit. It's just a lot going on. And then after that, that's when the police gets here.
Okay, so you all live in the same household?
Yes.
Has this ever happened before?
No.
Are you afraid of her?
No.
Do you want her back in the household?
No.
All right, thank you you do not want her back in the household?
No, ma'am. No, sir.
Okay, and all right, thank you for being here this afternoon, Ms. Wilson.
You're welcome.
Yes, Mr. Merrill.
Yes, Your Honor. So I do understand that the residence is located at 2798 Peak Road. I do believe that from my conversation with Ms. Connor, she would be able to go to a Powder Springs address. Given that the state's request is a signature bond, a $1,000 signature bond, the defense is, of course, Not objecting to that. And that just a little bit about my client. She is 25 years old. She has been living here over a decade, Your Honor, and she was working prior, but she is currently unemployed. And for her, in support of her, I just want to recognize that Miss Wanda Essex is here. That is her Essex, that's her mother, as well as her father and stepmother is present on the Zoom under Gerald and Teresa Connor, or I did see them earlier, but they were present here to support. Oh, they are here. There's Gerald and Teresa Connor. They're present to support her. Nothing further from the defense.
Very good. Well, and everyone that's here is welcome. Thank you for being here this afternoon. It will be $1,000 signature bond through pretrial level 1. No further contact with Miss Wilson. Stay away from the incident location. She can go back to that location on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, or weapons while out on bond. Good luck to you, Miss Connor. Okay, who do we have next?
And Mr. and Miss Connor and Miss Essex, I'll give you a text message when I finish, but it's a signature bond. You can log off.
Number 6, Mr. David.
Good afternoon, Mr. David. You have been charged in case 25 CR 0015553E with willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
Third arrest, 2025 DUI open, 2017 fleeing an officer. Should have went to felony earlier for robbery by intimidation. That's it.
Thank you. Ms. Malgizo?
Yes, Your Honor. On March 24, 2025, the defendant, Joshua David, attempted to enter ATL Exotic, a vape shop located at 8540 Roswell Road, Atlanta, Georgia. However, Chris Kendra, he's an employee at the vape shop, stopped him since he recognized Mr. David from a previous incident that occurred on March 22nd, 2025, where the defendant went behind the counter and took some merchandise. The employee contacted the Sandy Springs Police Department, provided a description of the defendant's vehicle and the direction that he was going. Officer Spencer with the Sandy Springs Police Department located the vehicle, which was turning into the Quick Trip gas station located at 7884 Roswell Road, Sandy Springs, Atlanta, Georgia, 30350. After being pulled over, the defendant exited the vehicle and began to walk away, ignoring the officer's commands to stop. Officer Spencer grabbed the defendant, and the defendant attempted to flee. He continued to resist even after he was placed in handcuffs. Several officers had to arrive at the scene and assist getting the defendant detained. Your Honor, we are recommending a $1,500 surety bond, no drugs, alcohol, or weapons while on bond. Stay away from ATL Exotic, the vape shop located at 8540 Roswell Road, Atlanta, Georgia. We're asking for a surety bond because he does have an open robbery case, which is pre-indicted, and that's a felony. So that's the reason for the surety bond.
Thank you, Your Honor. There's a problem with video, with audio. I think you wanted me to go ahead.
Yes, sir.
Okay. Joshua David is 38 years old, Your Honor. He went to Milton High School and also to a technical college, Lanier Tech, with several locations. In the Buford location, and Your Honor, he earned his certificate in automotive technician. For over 15 years, he's been a mechanic for car repair, and we would ask the court, even given the arrest record, to grant him a signature bond. He does have a Alpharetta 30009 address. He's got 2 phone numbers, one being the emergency. He shouldn't have any trouble getting to court.
Okay, it will be $1,000 good bond. Stay away from the incident location. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. David.
And then we're going to number one, Mr. Arnold.
And who's representing Mr. Arnold?
It's a conflict.
Ms. McLeod, good afternoon. Are you with me?
Good afternoon, Your Honor.
You represent Mr. Arnold?
I have not spoken to him, Your Honor.
Okay, we'll need for Mr. Arnold to be made available so that Ms. McLeod can speak with him if we can, courtroom 2.
Okay. So next we'll go to number 4, Mr. Conway.
Good afternoon, Mr. Conway. You have been charged in case 25 CR 001549B with battery, family violence, and 2 counts of cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
Third, 2016 battery, 2012 criminal attempt to commit a felony, dismissed.
Good afternoon, Ms. McConkey.
Good afternoon, Your Honor. This is an incident from August 8th of 2024. This incident occurred at the Economy Hotel located at 9995 Old Dogwood Road in Roswell. The victim in this case is Miss Alicia Galori, who used to live at the incident location with the defendant. The parties were having an argument over the state of the room that they were in when they began to mutually shove each other. At one point, the defendant shoved the victim so hard that she fell on her face, causing her front tooth to break, after which point the defendant left the location and turned off his phone. This incident did occur in front of the victim's 2 minor children who have the initials DMC and DC. Our office has spoken with the victim, Ms. Valori, who states her and the defendant are no longer in a relationship. They no longer live together. They share no children. She states they were staying at the hotel at the time of the incident, but she is no longer living there. She did confirm the events in the warrant, stated nothing like this has ever happened before, and they have spoken a few times since this incident. She states that she's not in fear of the defendant. However, she does not want to have any contact with him. The state's recommendation for Mr. Conway is a $3,000 surety bond, that he have no further contact with the victim or her minor children, that he have no drugs, weapons, or alcohol while out on bond, and that he undergo a day or 2 of anger awareness. I would ask the court to sound for the victim, Miss Alicia Galori.
If Ms. Galori is on the line and wishes to address the court, now is your opportunity. Doesn't appear so. Mr. McLean?
Your Honor, Mario Conway has a Somerset Street Fairburn address, well away from that location. He went to Morrow High School and then graduated from Youth Challenge Academy. He has worked for over a year at the current employer, changing oil and doing car repairs. Before that, he worked about on average of about a year or 2 each time at the Waffle Place and a McDonald's and a Walmart in the tire department. So he's quite industrious. We would ask the court under these circumstances and with that arrest record to grant him a signature bond.
For the battery, it'll be a $3,000 signature bond through pretrial level 1. For each of the cruelty charges will be a $500 signature bond through pretrial level 1. Makes for a total of a $4,000 signature bond through pretrial level 1. No further contact with the alleged victim. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Conway. Courtroom 2. Do you have Hayden Ferguson in your court?
Your Honor, I tried to see Hayden Ferguson today. We saw him in a cell. Your Honor, his
I see
situation.
that he has a private attorney, Mr. McLean. That's why I'm asking. Is
Oh.
Mr. Sally, is Hayden Ferguson your client?
It is, Judge. I've not had an opportunity to speak with him. We were just hired on it a few hours ago.
Okay. Is Hayden Ferguson in courtroom 2?
No, sir.
Okay, is he gonna be available this afternoon?
I'm not sure. I don't know if he mentally able to come in the courtroom, but we'll see though.
Oh, he's on the poll sheet. He has a private attorney here that I need for him to speak with. If he's not gonna be here, then I need to know why, and we'll have to reset him if it's a medical problem. But if not, I want him made available so that his counsel can speak with him, okay?
Would Your Honor like me to call the private counsel and tell him?
I would prefer for the counsel to speak with him personally, but if that will be it's up to you all. Mr. Sally, do you want to speak with Mr. McLean regarding Mr. Ferguson?
Sure, I can do that in the meantime. Eventually I'd like to speak with him if he's available this afternoon.
Of course.
Mhm.
Yeah, I'm not saying he's not going to be available. I just could preview it for him.
Sure.
Okay, so if you want to put your number in the chat, Mr. Sally, Mr. McLean will give you a call.
Thank you, Judge.
You're welcome. Who do we have in courtroom 1 there?
Number 5, Mr. Curtis.
That's my client, Your Honor.
Good afternoon, Mr. Curtis. You've been charged in case 25 CR 0015552C with battery family violence. Is there a history?
17. 2020 ag assault dismissed. 2020 simple battery conviction. Well, he got two 2020 simple battery convictions. Probation violations from 2017, 16, 15, and 14. 2014 simple battery arrest, 2012 FTA, and a 2010 battery DV arrest.
Thank you. Yes, Ms. Malgizo.
Yes, Your Honor. This incident is from November 30th, 2023. The victim is Frank Moore. The incident took place at 1483 Arthur Langford Jr. Place Southwest, Atlanta, Georgia, 30315. On the day of the incident, the defendant, Antonio Curtis, who is Mr. Moore's cousins, were and the victim were sitting in the living room. The defendant started to act aggressive and told Mr. Moore to go to his room. Mr. Moore responded by saying that he was not a child. At this point, the defendant grabbed Mr. Moore's shirt, flipped him onto the table, and ultimately threw him on the floor. Mr. Moore stated that his knee was twisted and that he hit his head on the floor when he was thrown to the ground. Officers did notice that Mr. Moore's ankle was swollen. The defendant was gone from the apartment before the police arrived. The defendant and the victim lived together when the incident occurred, but this was back in 2023. We tried to contact the victim. We left a message and sent a text message. We have not heard back. The state's recommendation is a $1,500 signature bond through pretrial with conditions: no contact with Frank Moore, stay away from the location, although we don't know if the victim still lives there. Just to make sure, stay away from 1483 Arthur Langford Jr. Place, Southwest, Atlanta, Georgia, 30315. No drugs, alcohol, or weapons while on bond.
And just to make sure, a $1,500 signature bond through pretrial. Is that correct?
Yes, Your Honor.
Okay. Any objection to any of the state's requests, Mr. Merrill?
Nope, not at all, Your Honor.
Okay. It will be a $1,500 signature bond through pretrial level 2. No further contact with the alleged victim. Stay away from the incident location. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Curtis.
That'll be per judge, Holly.
That'll be per judge, apparently, Ms. Bridgewater. And you can also put on there that it was a recommendation from the state. Who do we have in courtroom 1?
Okay, a breakout room between Ms. McLeod and courtroom 1. And who's next? Number 8, Mr. Howell.
If you can do Mr. Howell is what am I trying to say? Is Mr. McLean, you don't have any other women over there, do you? Courtroom two?
The women, I only had that one.
Oh, okay. All right.
Okay, let's see. So can we go ahead and place Ms. McLeod in courtroom one into a breakout room, please?
Yes, sir.
Thank you, Ms. Grace. Where are we going next?
If we go to number 9, Mr. Hughes.
Good afternoon, Mr. Hughes. You have been charged in case 25 CR 001-555J with battery, family violence, and possession of marijuana less than an ounce. Is there a history, Mr. Howard?
13. As an open battery DV and battery against a female who is pregnant. It's 24 CR 005093J. Probation violations from 2020, 2023, 2018, 2017 simple battery DV conviction. That's it.
Thank you. Good afternoon, Ms. Dunlap.
Good afternoon, Your Honor. Just to put on record, that open case is with the same victim. They were supposed to have no further contact, and he was supposed to also stay away from this. He was out on a $3,000 good bond from Judge Mincy. The facts of this case, Your Honor, this happened on March 23rd, 2025 at 2301 Godby Road in College Park. Officers responded to a verbal dispute and spoke with a Miss Deja Kamei Joe Hughes and her mother, I'm gonna say her grandmother, a Miss Joan Johnson. She said that the defendant, who was the father of her child, came to the apartment to spend time with their son. They got into a verbal dispute when he asked to spend the night, and she said no. He refused to put the son down and leave the apartment. And while attempting to get her son back from the defendant, he pushed her several times, leaving a large red mark around her collar. Ms. Joan, who was the victim's grandmother, called the police to the location. Regarding the marijuana, the defendant was searched for weapons, and officers found a Swisher green package in his pocket that amounted to 3 grams. As I previously put on record, he was previously arrested for battery family violence against Ms. Deja on that was July 24th, 2024. I also did have a chance to speak with Ms. Deja. I believe she is on Zoom because sound for her when appropriate. She said they are not in a relationship. They do not live together. The child is 4 months old. Looking at the notes from the previous case, she has stated to our victim advocate, I think it was about a month ago, that he tried to break into her house and broke her phone. He's been showing up to her house, knocking on her door. She has had to call the police several times. She stated she wants contact with the defendant because of their child, but as I stated before, there was already a no further contact on this case, on the previous case. And since then, we just want to make sure that the defendant is aware of the no further contact. There have been 15 calls made from the jail to Ms. Deja since he's been in. And as such, Say is looking for a $6,500 surety bond. That's 6 on the battery, 500 on the marijuana, and no further contact with Deja. As Kamei, Camay Hughes, a stay away from 2301 Godby Road in College Park Family Violence Intervention Program, and no drugs, alcohol, or weapons while on bond. And we can sound for the inappropriate.
First, Ms. Deja Hughes, if you would like to address the court, now is your opportunity to do so. I will need for you to unmute yourself. Raise your right hand for me, ma'am. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. What would you like to tell the court?
I would really like, whenever they asked me if I wanted to press charges, I said no, because I didn't want him to go to jail. I just wanted him to leave because we were arguing. And because of what was going on, I just wanted him to leave. I didn't want him to go to jail because he does help me out with our son and things like that. Even if we don't have contact, he still does, not like with money and stuff. I mean,
let me make this very clear to you. I see you have a young child there. You all ought to have no contact, period. Okay? You've been ordered that by another judge in another situation where he's allegedly accused of the same thing that he's accused of in this case. As such, you're to have no contact. No contact means absolutely no contact. Obviously, no physical contact, no phone contact, no internet contact, no social media contact. No contact means no contact. If you had no contact, he wouldn't be sitting right where he is sitting now, okay? So if you're allowing him to be around you and your child, you're not doing him any favors because he's going to keep being where he is. You have been ordered not to have any contact, Mr. and Ms. Hughes. So this court expects that there will be no contact until this is resolved. You understand me, ma'am?
Yes, I do.
All right, very good. Thank you for being here this afternoon. There was somebody else that wanted to speak on this matter as well.
Your Honor, that's the defendant's mother, and I imagine that would be content oriented rather than bond procedure oriented. So I don't think it would be useful at this time.
Okay. Yes, Mr. McLean.
Michael Hughes is 28. He has an Athens address, so he can stay at 65. The Clark Central High School is where he graduated high school. He is an automotive technician ever since, 2017. He's also worked at restaurants in the past. He would ask for the court to grant even under these circumstances, realizing what has gone on before, he would like to ask the court for a signature bond if that's possible, and if not, just the lowest surety bond, such as $1,000.
Well, I'm not going to go that way because he's already gotten a $3,000 surety bond for the other case that he's in. So we're not going to go backwards. For the battery, it's going to be a $6,000 good bond. For the possession, a $500 good bond. It makes for a total of a $6,500 good bond. No further contact with the alleged victim. Stay away from the incident location. No drugs, alcohol, or weapons while out on bond. Your client has his hand up, Mr. McLean.
I can call the courtroom and answer any questions you've got. I believe it's at 2060. I'll be.
All right. Your Honor, I understand where you're coming from with the no contact, but I have messages on my social media where Mrs. Hughes has been the one reaching out to me. She's reached out to my mother telling me to come back home, which is to the 2301 Godby Road address. My mom has a Ring camera. The van that Miss Hughes drive, that van will be seen, it can be seen on my mother's Ring camera picking me up. And I understand I'm at fault because I'm still not supposed to have contact with her.
Hold on, Mr. Hughes, don't go too far into that.
Okay, so yes, you have a right to remain silent. Mr. Hughes, you're not to have any contact at this point in time. I've made that very clear. I've made it very clear now to Ms. Hughes. If she tries to contact you, I suggest that you contact your lawyers and let them know. Or if you believe that there's something else going on, you need to contact the police. But you're to have no contact, and you need to not put yourself in a situation where you're going to be in violation of a bond order. You understand me?
Yes, sir. So when it comes to me getting my property from her house, can I have the police go with me?
You were probably given a one-time escort before. You shouldn't have any property at her residence. You can utilize a third party to get any property that you have there. I will allow you on this one occasion to have a one-time police escort to retrieve any belongings. But given that were given a stay away before, there shouldn't be any belongings there. So there shouldn't. Yeah. You shouldn't have that, but I'll give you that request on one occasion. All right, good luck to you, sir. Who do we have next?
Number 8, Mr. Howe. Oh, shit.
Good
This is who?
afternoon. This is position number 8, Mr. Howell. Good afternoon, Mr. Howell. You've been charged in case 25 CR 0015557B with 2 counts of simple battery family violence. Is there a history, Mr. Howard?
4. Last was 02.
Yes, Ms. Dunlap.
Thank you, Your Honor. This incident date happened on February 20th, 2025 at 415 Armour Drive Northeast in Atlanta. Officers responded to a domestic dispute between a husband and wife. They spoke with the victim, a Miss LaShonda Winston Howell, who stated she was assaulted earlier in the day by the defendant, who was her husband. She stated the defendant shoved her against the wall by her desk, grabbed her by her neck, and banged her head into the cabinet several times. The couple's adult son was present during the incident, who stated he heard the argument, but he didn't see the defendant strike her. Mrs. Howell told officers they are going through divorce and they are separating, but the defendant refuses to leave the location for a week until she can move out of the home and pack her belongings. Our office did have a chance to speak to the victim. She stated that they are married, they live together at the incident location. She stated that he hit her head against the wall, not slammed, and she's since spoken to him. And she's okay with having no further violent contact. The state is, it looks like she has also left the residence. So the state is still looking for a $4,000 signature bond through pretrial. No further contact with Miss LaShonda Howell. The stay away won't be necessary if she has in fact left the address. 1 day anger awareness and no drugs, alcohol, or weapons while on bond.
Yes, Mr. Merrill.
I've got it.
Oh,
No,
Mr. McClain.
sure. No objection, Your Honor.
All right, for each of the simple batteries will be a $2,000 signature bond through pretrial level 1, makes for a total of a $4,000 signature bond through pretrial level 1. No further contact with Ms. Howell. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Howell.
It's like number 1, Mr. Arnold is ready.
Okay.
Your Honor, Mr. Arnold has indicated after a conversation that he wishes to represent himself.
Okay, if you unmute there for me, courtroom 1, please. Mr. Arnold, good afternoon again. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. You've been charged in case 25 CR 001519J with violating the Family Violence Protective Order. Is there any reason that you do not want representation this afternoon? Mr. Arnold, can you hear me?
Correct. The attorney is lacking acknowledgement for representation to represent me.
Say it again for me, sir.
The attorney that did not make themselves known to me with any type of verification, it doesn't have any acknowledgement to represent me for the charges.
Okay, I'm not exactly sure what you're trying to tell me, but Ms. McLeod here, she is a Georgia attorney. What do you want? Something more than that? I'm happy to let you go forward and represent yourself this afternoon.
She would have to provide acknowledgement and agreements to let me know that.
Okay, well, I'm letting you know it. So, okay, I'm gonna allow you to represent yourself, Mr. Arnold. Does he have a history?
Yes, 10 total. He has an open simple battery in state court. It's 25 CR 000749J. Got an open trespass obstruction 22 CR 006665J. 2025 FTA 2013 trespass conviction.
Okay, yes. Good afternoon, Miss Allen.
Oh, it's my case, Your Honor.
Oh, I'm sorry. There are
No problem.
so many people here this afternoon.
No, I'm not trying to distract you. I'm just supervising.
All right. Yes, Miss McConkey.
This is an incident from February 20th of 2025. The incident location is 88 Howard Street Northwest in Atlanta. The victim in this case is Miss Bess Arnold, who is the defendant's 100-year-old grandmother. The defendant currently has a no contact order from that simple battery case that Mr. Howard mentioned, where he was ordered to have no further contact with Ms. Bess Arnold and also to stay away from that incident location. Per the warrant, an individual named LaToya Moore, who the defendant is also not supposed to have any contact with, called the defendant's grandmother and told her that he was at the house. The grandmother then went over to the house and told the defendant he needed to leave. He proceeded to refuse, stating that he had a right to, in fact, be in that home. The victim was scared to enter the house, so she only spoke to him through the screen door. And then when he said he wasn't leaving, she proceeded to call the police. Given the fact that he has an FTA, 2 open cases, one of which does include that stay away and no further contact order. So he's now in violation of that 25 CR 749J bond. That bond was signed by you, Judge Morrow, on February 13th, 2025. We don't believe that he is a candidate for a signature bond, so we are asking for a $2,500 surety bond, that he again have no further contact with LaToya Moore and Bess Arnold, which he was already ordered to do, that he stay away from that incident location, no drugs, weapons, or alcohol while out on bond. In his previous case, he was ordered to have a social worker visit. I'm not sure if that occurred. If that hasn't occurred, then we would recommend that he have a social worker visit. I would ask the court to sound for Ms. LaToya Moore and Ms. Bess Arnold.
And did you say, Ms. McConkey, that I gave him a signature bond the last time?
You did. You gave him a $2,000 SOB.
Okay, thank you. Ms. Moore or Ms. Arnold, if either of you are on the line and wish to address the court, now is your opportunity.
Judge, your video is off, just so you know.
I'm sorry, say it again.
Your video is off.
Thank you. Again, Ms. Moore, Ms. Arnold. All right. Mr. James Arnold, I've seen you before. The last time you were before me on that simple battery charge, I gave your signature bond. This time it will be a $2,500 good bond. Again, I'm going to tell you that you can have no further contact with either Bess Arnold or LaToya Moore. No contact means absolutely no contact. No drugs, alcohol, weapons while out on bond. And I would like for him to have a social worker visit to assess for BHET. Good luck to you, Mr. Arnold. Who do we have next?
Your Honor, repeat that bond amount again, please.
$2,500 good bond.
2,500. Thank you.
You're welcome. Ms. McLeod, thank you for assisting on that this afternoon.
You're welcome, Your Honor.
Next we have number 10, Mr. Hall.
Good afternoon, Mr. Hull. You have been charged in case 25 CR 0015550Y with DUI drugs, less safe, following too closely, and no insurance. Is there a history, Mr. Howard?
2021, possession of a Schedule 4, possession of tools. 2017, shoplifting conviction. 2015, DUI, dismissed.
Thank you. Ms. McConkey?
Yes, Your Honor. I also see that he has a 2009 conviction for a DUI as well. This incident is from March 22nd, 2025. Officers were dispatched in reference to a traffic incident where the defendant rear-ended another vehicle. While officers were speaking to the defendant, they noticed that he had slurred speech, his eyes were watery, he was drooling out of his mouth, and he was also swaying while he was standing. The defendant told officers that he had only taken a Xanax for a medical condition, but he did agree to undergo some field sobriety tests, which all did indicate that he was impaired and under the influence. After completing the test, the defendant was arrested, and he also did agree to take a blood test. I believe those results are still pending. It was also discovered that the defendant's insurance had expired, and he did not have insurance at the time of the incident. The state's recommendation for Mr. Hall is a $3,000 surety bond, no drugs, weapons, or alcohol while out on bond, no driving without a valid insurance, and other valid documents. This recommendation is based on the facts of the case and also on his history, which does include some arrests for a DUI and also a DUI conviction.
Who's representing Mr. Hull?
It's actually going to be Mr. McLean. He's just said that he have a little technical issue, so he said he'd be back and he's fixing his audio situation.
Thank you.
There he is. Mike, you're muted.
I didn't see Mr. Hall today, but I'd be glad to interview him on a breakout.
Okay, anybody else that you need to interview this afternoon, Mr. McLean? So we can do that all at one time?
Not that I'm aware of, Your Honor, no.
Okay, if you could make Mr. Hall available for Mr. McLean. Courtroom 2.
Okay. So,
And Your Honor, I have both of the ladies in ACDC if you want to bring the ladies. And I have both of those. Those are both my clients.
yeah, we'll go there.
And then we also have a client in which we're waiving their presence, which is Mia Oliver. She's also assigned to me just to kind of keep the ball rolling.
Okay, thank you.
No problem.
I have another client as well, Mr. Jones.
Okay. So let's see. Friend, are we gonna go to ACDC? Where you all just let me know where you want to go.
All right, we can do number 11 now, then go to ACDC.
So this is Mr. Jones in courtroom 2?
Yes.
Okay, so we'll do Mr. Jones, then we'll go to ACDC. Good afternoon, Mr. Jones. You have been charged in case 25 CR 001547G with battery. Is there a history, Mr. Howard?
2017 probation, 2011 a freight conviction.
Ms. McCockey?
Yes, Your Honor. I saw that he also had an arrest in 2025 for acquiring license plate for purpose of concealing identification of a vehicle. This incident is from yesterday. It occurred at 244 Milton Avenue Southeast in Atlanta. The victim in this case is Shakina Carpenter. Officers conducted a traffic stop after they observed the defendant driving with the passenger side door open. Upon stopping the vehicle, they made contact with the victim, who advised that the defendant had assaulted her and dragged her outside of her home during an argument. Officers did observe visible injuries to the victim's left elbow, as well as injuries to her knees, which she stated that she sustained as a result of the defendant assaulting her. Our office had the opportunity to speak with Ms. Carpenter, who states that her and the defendant are friends. They do not live together. They share no children. She did confirm the events in the warrant, stated the defendant was also hitting her while he was pulling her out of the car. The victim's mother then got on the phone and stated this is an ongoing issue between the victim and the defendant, and they are always fighting each other and they do not need to be in contact. The victim does currently have an open case against the defendant, 23 CP 222636. In that case, the defendant is the victim and the victim is the defendant. In that case, the victim was ordered to have no further contact with Mr. Jones. The state's recommendation is a $3,000 surety bond for Mr. Jones, that he have no further contact with the victim, that he stay away from 244 Milton Avenue Southeast in Atlanta, that is the victim's residence, that he undergo a day or two of anger awareness, no drugs, weapons, or alcohol while out on bond. And it should be noted that the victim is, I believe, 21 years old, so there is a significant age difference here. I would ask the court to sound for the victim in this case, Ms. Shakina Carpenter.
Ms. Carpenter is on the line and wishes to address the court. Now is your opportunity. Ms. McLeod?
Yes, Your Honor. My client denies the allegations in the state's warrant. He tells me that he was at the particular location where the incident first started, and this victim, when he was leaving, she jumped into his car, and he was trying to tell her to get out of his car, and she refused. He tried to call 911. In fact, he said he did call 911. She grabbed the phone out of his hand, and she was the one who attacked him. As the state has said, he has another case where she was the aggressor, and she was arrested and ordered not to have any contact with my client. I don't believe my client has any significant history after 2011, based on what I heard pre-trial say, Your Honor. He has 3 children, he tells me. The youngest one, who's 7 years old, lives at home with him. He tells me that he is a tattoo artist, that is what he does for a living, and that he really does not want to have any contact with this young lady. And she was the primary aggressive, and she was the one who jumped into his car, which makes sense. She was in his car, even though she was told not to have any contact with him, Your Honor. I'm going to ask the court to consider a signature bond for my client so that he can get out of jail. Nothing, and we are okay with no further contact with the alleged victim.
Okay. It will be a $2,000 signature bond through pretrial level 2. No further contact with Ms. Carpenter. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Jones.
Could
Thank
we
you,
also
Your
have
Honor.
a stay away from Ms. Carpenter's residence? That's where the incident occurred.
Okay, and a stay away from her residence.
Excuse me, Judge. I'm sorry. Could I say something?
Is this Ms. Carpenter?
Yes, it is.
Okay, I sounded for you earlier, Ms. Carpenter. If you would like to address the
I
court, I'll
was
need to.
I was
Okay,
trying to
you're
come off
fine.
mute.
Okay, you're fine, ma'am. Can you come on camera for me?
Yes. Let me see how it comes. It's not. Hold on. It says it's unavailable, but it's not letting me do it. I'm on the internet.
Oh, okay. So, Ms. Carpenter, I'll be happy to let you speak, but I need to be able to see you. Just let me just listen to me. Since you all have charges against each other, you also have a right to remain silent, and anything that you say can be used against you. Apparently, it's already been ordered that you're not to have any contact with him. I'm ordering now that he's not to have contact with you. So neither of you all should be having contact with one another at the present time until this is all worked out. Okay?
Yes, Your Honor, I understand. I just wanted you.
Okay. Okay. So hold on. Again, I'm not able to, because I can't see you, ma'am. I'm not able to take any testimony from you or hear from you. But I just want to make sure that you understand that y'all aren't supposed to have contact. Okay.
Yes.
All right. Have a good rest of your day, ma'am. Who do
Your
we have
Honor, for
next?
some reason, it's chopping up on my end. What was the bond amount for Mr. Jones?
It
It
was
was a
2,000.
2,000.
Okay.
It's fine.
And that
Go
was
ahead,
level
Mr.
1,
Level 2.
level 2. Thank you.
Okay. You have everything we need, Miss Bridgewater?
I think so. Thank you, Your Honor.
Okay. Very good. All right, so we're going to ACDC, I believe. Good afternoon, Francois. Who do we have?
Good afternoon, Judge Morrow. As you already know, position 13 is going to be waiver of appearance with Oliver.
Okay.
Okay, and then we have Ms. Brooks. This is position number 2.
Yes, good afternoon, Ms. Brooks, and let me address the other young lady that's there with you as well. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney, we're providing you with the assistance of a public defender this afternoon if you choose to utilize their service. Ms. Brooks, you have been charged in case 25 CR 0015556A with battery family violence. Is there a history, Mr. Howard?
Third arrest, no violence.
Okay. Yes, counsel.
Yes, Your Honor. This incident is from March 23rd, 2025. The incident took place at 396 Piedmont Avenue Northeast, apartment 5010, Atlanta, Georgia, 30308. The victim in this case is Justin Hunter, but he was also arrested. So in this case, the defendant was the victim and the victim was the defendant as well. I checked earlier, but I didn't see a case or a booking number for Mr. Hunter in the system. But the report stated that they were both arrested for this incident. They do live together. The defendant and the victim are boyfriend and girlfriend. On the day of the incident, the defendant and Mr. Hunter got into a verbal and physical altercation. Officers observed that the defendant was walking with a limp and that her face was swollen. Mr. Hunter had a laceration on his thumb, and there was blood stains over his shirt, pants, and socks. The laceration to his thumb resulted from Ms. Brooks biting Mr. Hunter's thumb. The state's recommendation is a $1,000 signature bond through pretrial. Conditions: stay away from the location, 396 Piedmont Avenue Northeast, apartment 5010, Atlanta, Georgia. No contact with Justin Hunter. No drugs, alcohol, or weapons while on bond.
I'm sorry, you going in now or you asking for me?
Yes,
Oh,
you
no
can
objection.
proceed.
Oh, yes, no objection for the signature bond. Your Honor, as indicated, the incident happened at 396. It's my understanding that she would have a different address to go to when I spoke with her, Your Honor. Nothing further from the defense.
Okay. It will be a $2,000 signature bond through pretrial level 1. No further contact with Justin Hunter. Stay away from the incident location. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Brooks.
Next, we have position, this is the add-on, Ms. Fountain, position number 1.
Good afternoon, Ms. Fountain. You have been charged in case 25 CR 001560E with 2 counts of abandonment of dependent child, disorderly conduct, and criminal trespass. Is there a history, Mr. Howard?
25. Got an open burglary in Clayton County. 2023 FTA, 2023 giving false name conviction. 2019 probation. 2018 giving false name NOLO. 2016 ag assault arrest. 2016 disorderly conduct conviction. 2015 probation. 2013 FTA and a shoplifting conviction. That's it.
Your
Ms.
Honor, that's
Allen?
my case.
Okay.
This incident actually started, I guess the incident actually started on the 22nd. The defendant in front of you has a set of twins, both with the same initials, and the same date of birth, obviously. Police were called on the 23rd. She was at the location, a residence at 1100 Rebel Forest Drive, Southeast. That's the residence of Mr. Johnny Hurd, who is an acquaintance of hers and knew, I believe, her boyfriend previously. The residence is owned by Mr. Freeman Durham, who allows Johnny Hurd to live there. The defendant came over on the 22nd with her children and asked Mr. Hurd, who's 67 years old and was just released from the hospital, if he could watch her children for a few hours so she could go get a car. And he did that, and she left and came back with a car. She then came to the location with bags of clothing and reported that her current boyfriend had kicked her out and she was unstable and needed a place to stay while she figured out where she was going to go. The landlord, Mr. Freeman Durham, as well as Mr. Hurd, informed the defendant that she was not going to be able to stay there, that they could not help her any more than they already did. They took some action to try to find her a room, suggested a shelter she could go to with her children, and she refused. She then, when it was about 10 p.m. on the 23rd and getting late, especially for little children who are under the age of 1, sitting in car seats, she was directed that she needed to leave the location, that she could not stay there. She could not bring her bags of clothing to the location. She refused. And then when police were called, she left the location in her car, leaving the children there. The police report indicates that as Officer Fambro approached the location, he actually passed by the defendant, asked her if she called 911. She said no, that he reports in his report and in the warrants that she appeared intoxicated and was described as irate, and she got into her vehicle and she left. Her 2 infants, still in their car seats, were inside the residence there at 1100 Rebel Forest Drive, Southeast, and she had left the location. Both Mr. Freeman Durham and Mr. Johnny Hurd spoke to police in depth SVU and Grady were called. The children were taken down to Precinct 3, where Grady assessed them, and then they were taken to Hughes Spalding, and DFACS was notified. They were removed and taken into custody. At a certain point, officers made contact with the defendant, who said that she left them with Mr. Hurd, and she went to work, and she was not coming down to the hospital. Police notes also indicate that Mr. Hurd and Mr. Freeman Durham, when they reported about the interactions with the defendant, reported that she absolutely lost her mind and became volatile, was refusing to leave, was heavily intoxicated, and they just didn't know what else to do at that point besides call 911. They were asking her to leave multiple times. Ultimately, while police were still at Hughes Spalding, the defendant arrived with a family member or a friend. Her name is Brenda Robinson. Police took her into custody, and Brenda Robinson took her keys and her phone. We tried to reach out to her family member or Mrs. Robinson and were unable to make contact with her. But I did specifically speak to Durham Freeman and Johnny Hurd today, and got all of this background information. I did also confirm with our liaison through DFACS that the children are in care at this point. Based on the history, she's got a failure to appear in an open burglary out of Clayton County, multiple prior arrests and convictions for theft, felony drug conviction, and violence, Your Honor. But the majority of her convictions are for drugs and assaults. We're asking for a $4,000 surety to stay away from that location, 1100 Rebel Forest Drive, Southeast. Have absolutely no contact with Freeman Durham or Johnny Hurd, and to follow through and be compliant with any DFACS requirements related to the care of her children and contact with her children. It's the state's position that we're not interested in piling on what's already a situation where this young woman needs some support, but ultimately, we respect the services that DFACS is providing, and hope that that will do some good in the future. We're also requesting no drugs, alcohol, or weapons, Your Honor. And we'd request random screens. Thank you.
Okay. Mr. Durham or Mr. Hurd, either on the line or wish to address the court, now is your opportunity. That appears so. Mr. Merrill?
Yes, Your Honor. This is my client, Ms. Robin Fountain, Your Honor. Just to kind of begin to go through the Ayala factors, Ms. Fountain is 38 years old. She has been living, um, oh, sorry. She has been living in Atlanta over a decade, Your Honor. While the incident location does happen it's alleged to happen at Rebel Forest, she does have a different address out of Atlanta, that she can be able to stay at. Your Honor, as indicated, as we know, she does have the twins who are about 1 years old, 18 months. Um, she does have a severe health diagnosis. I just want to put that in there because she has congestive heart failure. So her care is very important. She is being actively seen for this congestive heart failure. And prior to this incident, she does, as indicated, she was working. However, because of this arrest, she indicates that she probably is going to be unemployed, Your Honor. And so I mentioned that because any bond that's set higher, I know the state is only asking for 4,000. Any bond set higher than 5,000, I won't be able to use the bail project to be able to get her out, Your Honor. I do indicate that, Your Honor, that just I see that the state had um added two charges from what the warrant listed, which is a disorderly conduct and a criminal trespass, Your Honor. And I also recognize that the state is going, I mean, not the state, the court is going to be concerned about the fact that she does have two FTAs. And I would ask that if it could be per judge, that on the counts of the disorderly conduct and the counts of criminal trespass, if those can still be given an FTA, not FTA. You can be given a signature bond, Your Honor, because our basis is that the disorderly conduct, according to the accusation, is stating that it doesn't even list a specific act, Your Honor, and according to the warrant, she was being argumentative. If that's the case, I'm committing disorderly conduct every day. Um, Furthermore, Your Honor, the criminal trespass, The warrants does say that she haven't received notice, but of course I haven't received any copy of any notice, and I didn't hear that she had a previous criminal trespass with Mr. Tucson. But also, Your Honor, I want to point out that when it comes to the abandonment of the dependent child, Your Honor, the case law is clear that there's two things that has to be present, and that it has to be not only just that the dependent, but also that the child was left in a dependent um condition without sufficient food, shelter, or clothing. That was indicated as a note of decision by Carter v. State. That citation is 287 Georgia App 463 2007. I mentioned this because, Your Honor, as you've heard in the recitation of the facts according to the state, the officer walked right past Miss Fountain. It's impossible, Your Honor, for the mother to have left the child in a dependent condition if the officer had just literally immediately walked past her. Also, Your Honor, Mr. Hurd, who, as indicated by the state, has previously watched Miss Fountain. It was no secret that Miss Fountain was at this location. It's also no secret that the children was there. Your Honor, defense has issues with believing that Mr. Fountain had no idea that two small children who would cry all the time, we're talking about 1-year-olds, would be in his room and he had no idea. Your Honor, Mr. Hurd was inside of the home, Your Honor. And so we mentioned that because I am asking for a lower bond, Your Honor. I'm asking for a 2,000 bond, 1,000 on each abandonment, and then a signature bond on the disorderly conduct and criminal trespass as indicated. I understand you are concerned with the FTAs, but even with a 2,000 bond, it is a surety that if she does miss court, she will have to pay that amount. I mean, she can have her bond revoked, etc., and she still has to pay to be able to get out, especially for one who's unemployed. Nothing further.
Okay. For each charge, it will be a $250 good bond, makes for a total of $1,000 good bond. No further contact with either Mr. Hurd or Mr. Durham. Stay away from the rebel force address. Abide by any defacts orders. No drugs, alcohol, weapons while out on bond.
And Your Honor, if you would just entertain me for a moment, as far as the defects orders and contact with the children, just based on the recitation of the argument that we just heard, we would go ahead and ask for no contact with the children unless otherwise ordered by Superior Court in a separate matter. It sounds like there's no responsibility being taken here, and that's the exact opposite of what the state intended. I went very carefully through the facts and made multiple outreach attempts to people to make sure I understood what the full picture was here, and to be as gracious as possible. But it sounds like what's in the best interest of two very young children is not the focus right now. We would ask that until it's further ordered by Superior Court, there be no contact. And the children's names, their initials both are DF, Your Honor.
I'm extraordinarily reticent to keep a mother away from her two young children. So
Well, they've already been removed from her care.
Well, they're in defects' care, and defects is set up to deal with this. So I'm going to let defects handle the care of the children, and if this mother can have contact and whatever orders that they deem appropriate, this court will also let her abide by. So
Well, at this point, they're requiring no contact until they make another decision.
Okay.
And what you just heard from the defense is that she believes she left her children with someone who reportedly asked her to leave and said they could not let her stay there and they couldn't watch their children. She believes that that was okay and not abandoning your kids. So I do believe the state has put forward that there is a real concern here for some judgment on the part of children who have a date of birth of 9/25/23.
Okay, so this is just a bond hearing on this matter this morning or this afternoon. So whatever defects deems to be appropriate, I will let that stand at the present time.
Thank you.
Okay. All right, Ms. Johnson. Yes, Mr.
One last thing. On your order, can you also indicate that it can go through the sheriff's 10% program? Just because what happens with the bail project is that they pay the cash. And so they always ask if we can ask the judge. It just allows them to be able to pay 10% and not the entire It's like a good bond, basically through a bonding company.
Okay, Ms. Bridgewater, do you have what you need to make that stipulation on there?
No, if he'll repeat it, I'll write it on here.
Shares 10% program.
What 10% program shared?
Yep, shares 10% program. It means that when the Bell Project goes to pay the bond, they allow 10% like a bonding company.
Okay, are you saying sheriff or shared?
Sheriff.
Okay,
Sheriff.
gotcha. No problem.
Thank you.
All right. Good luck to you, Ms. Fountain. Who do we have next?
I'll call you.
Thank you, Judge. Do you have a question?
Oh, are we done at ACDC? Okay.
Number 14, Mr.
Next
Powell.
time.
I'm sorry, Judge. She has a quick question.
I'll let her ask I'll let her ask Mr. Merrill at a later time.
Thank you.
Okay. All right, courtroom 2, who do we have?
Number 14, Mr. Powell.
Okay.
Good afternoon, Your Honor. Zachary Taft on behalf of Mr. Paula.
Good afternoon, Mr. Tapp.
Mr. Paula is aware of the charges against him, and we would waive a formal reading of the charges, Your Honor.
Okay. Good afternoon, Mr. Pala. You have been, I won't sound the charge, counsel. You've been charged in case 25 CR 0015559D with 1 misdemeanor offense. Is there a history?
Yeah, 8th arrest. 2024 trespass, DUI. 2020 battery DV, entering 911 call conviction. 2015 false imprisonment, ag battery first offender.
Okay.
I'm not sure about that level. There might be a typo. I don't know. It's up to you though.
Thank you. Ms. Dunlap.
Thank you, Your Honor. Officers were called to K-Pot Restaurant by the manager who said the defendant was intoxicated and causing a disturbance. They wanted him to leave the restaurant. They initially thought the defendant left the restaurant and then he returned. Officers were informed by the victim, Sally Weldon, that she was sitting at the bar next to the defendant. When he invaded her personal space and kept looking at her phone, he did proceed to grab her buttocks and she pushed him off and walked away. Our office has spoke to the victim. She said that she doesn't know the defendant. She only came to this restaurant on New Year's Eve. I apologize. I didn't say the date this happened. This happened on January 1st, 2024. And she sat next to the defendant. She stated that he was intoxicated and was talking about breaking up with his girlfriend and leaned over and as I stated what he did before. She stated she pushed him off and she said something to the bartender and he was escorted out of the restaurant. She does not want contact and I don't believe she is on Zoom. The state is looking for a $2,000 surety bond on this case. A stay away from the K-Pop Hot restaurant. No further contact with Sally Weldon and no drugs, alcohol, or weapons while on bond.
Thank you, Your Honor. Mr. Paula has significant ties to the Atlanta area. He is a local business owner. We would not object to any of the conditions. We would ask for $1,000 bond if Your Honor were so inclined, but otherwise have no objections to the conditions of the release.
Okay, I want to send him through pretrial. As such, it'll be a $3,000 signature bond through pretrial level 2. No further contact with Ms. Weldon. Stay away from the incident location. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Pala. Anything further this afternoon, Mr. Taft?
No, Your Honor. May I be excused?
Yes, have a good rest of your day.
Thank you. You as well, Your Honor.
Thank you.
I'm going back to number 10, Mr. Hull.
I had requested through chat, whatever ASG is handling Mr. Hall, could they give me a call?
Mr. McLean, could you send me your number, please?
It's 5215. It's just a 612 number. 5215.
I'm sorry, I couldn't hear you.
Oh, it's a 612-5215.
5215. Okay, thank you.
Thank you.
We have anyone else in courtroom 2 that we can handle?
Number 12, Mr. Merton.
Representing Mr. Merton.
Him as well, Your Honor.
Okay, we'll hold off on him while Mr. McLean deals with, what about, position 15, Willie Stallings?
Yeah. Stallings.
I also have Stallings.
You also have him?
Yeah.
So the waiver, Mr. Merrill, do you have the waiver?
Sorry, Your Honor, I
Position
had a little issue. What did you say?
Do you have position 13, the waiver, Mia Oliver?
I do.
Okay, let's go ahead and do that case while Mr. McLean is finishing up I think the rest of the cases are his.
Okay.
All right, Ms. Oliver was charged in case 25 CR 0015558F with criminal trespass and willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
For 2025 FTO. 2013 battery cruelty in the third conviction. 06 simple battery hindering 911 call conviction.
Hey, Ms. Dunlap.
Thank you, Your Honor. This incident date was March 21st, 2025 at 232 Fallsworth Street Southwest. That is a Greyhound bus station. Officers responded to a call from security at the Greyhound bus station. The said defendant was asked to leave the property after several negative encounters with the security. Officers asked her to leave. She said because she was not a paying customer. Defendant responded and said another officer told her she could warm up there. She left out of the building and then was observed walking back inside, standing in the entryway. Upon being detained, she provided officers with the false name of Maiden Oliver. The state is looking for a $1,000 signature bond through pretrial, a stay away from 232 Fallsworth Street Southwest, and no drugs, alcohol, or weapons while on bond.
Any objection to any of that, Mr. Merrill?
No, Your Honor. It's just asked that you include wraparound. Wraparound with it.
Okay, so you want a social worker visit to assist
Yes.
with housing? Okay.
Mhm.
For each charge, it will be a $500 signature bond through pretrial level 1, makes for a total of $1,000 signature bond through pretrial level 1. Stay away from the Greyhound bus station on Bosworth Street. Social worker visit to assist with housing or any other necessity that Miss Oliver might have. No drugs, alcohol, weapons while out on bond. Okay. All right, Mr. McLean, have you gotten what you need?
Yes, Your Honor. Just give me 10 seconds more and I need to inform the deputy of something. Thank you.
Okay.
Okay, we're back. Your Honor, on Mr. Hall, we're ready.
Okay, we can bring Mr. Hull back up, please. We've already gone through everything out with Mr. Do you need to tell me anything more, Ms. McConkey?
After a conversation with Mr. McLean, we are agreeable to making our recommendation at $2,000 surety bond on the condition that he have random screens for alcohol and non-prescription drugs, in addition to no drugs, weapons, or alcohol, and no driving without valid insurance.
And we feel that random screens would be appropriate, and we'd like to ask the court to go with that joint recommendation.
Okay, so for the DUI, there'd be $1,000 good bond. For each of the other charges, a $500 good bond. Makes for a total of a $2,000 good bond. Random drug screens, drug and alcohol screens. No driving without valid insurance. No drugs, alcohol, weapons while out on bond. Is that pretty much the agreement?
Yes, Your Honor.
Yes, Your Honor.
Okay, very good. Good luck to you, Mr. Hull. Okay, who do we have next?
Number 11, Mr. Merton.
Okay. Mr. Merton's number 12. Good afternoon, Mr. Merton. You've been charged in case 25 CR 0015554Y with battery and 2 counts of simple battery. Is there a history, Mr. Howard?
14. On probation out of car for terrorist threats. Riot in penal institution. We got an open case out of Paulding County, given false name. 2022 battery DV conviction and wanted out of Marietta.
Okay, Ms. Dunlap.
Thank you, Your Honor. This incident date happened on March 15th, 2025 at 120A Fruitwood Trace in South Fulton. Officers responded to the location regarding a domestic dispute. They spoke with the female caller, a Miss, I believe it's Clashe Oliver, apologize if I'm mispronouncing it, spelled Clashe, who stated she was in a physical domestic dispute with the defendant, who was her boyfriend. She told officers that when she woke up, the defendant was questioning her about her whereabouts, and a verbal dispute turned physical when he grabbed her by her shirt collar, pinned her against the wall, and began striking her in the face and pulling her hair. Defendant then walked out of the house while continuing to make threats about harming her. Once he exited, she locked the door, which resulted in the defendant trying to break back into the home through the front and back door. Officers observed bruising to the face and neck of Miss Oliver. Ms. Oliver also stated to officers she has been previously physically assaulted several times by the defendant, but she didn't want it to get the police involved, as the defendant gets very jealous and suspicious of her. The state is looking for a $3,000 surety bond on this case and no further contact with Clashe Oliver. A stay away from 120A Fruitwood Trace, South Fulton. 1 day anger awareness, and no drugs, alcohol, or weapons while on bond.
Okay.
Thank you, Your Honor. Mr. Murden has graduated high school. He is 47 years old. He is a local person, been in Georgia all his life. He does delivery work by truck. He drives a truck locally for distribution, and occasionally they go out of state to Tennessee for over the road for the same distribution company. Your Honor, he would ask the court to consider the lowest possible surety bond if a signature bond is not available, but we would ask the court to consider a signature bond. By the way, he does have a minor child, and he has two near minor children. His minor child is 17, but frankly, Your Honor, he really is providing support for an 18-year-old and a 19-year-old as well, even though they're not technically minors. Those are college-age kids they're trying to launch, and so he has quite a bit of financial burden and needs the stability of keeping his job. So we would ask the court to consider a signature bond if that's at all possible, or the lowest surety if not.
Okay, for the battery, it'll be a $2,000 good bond. For each of the simple batteries, a $500 good bond, makes for a total of a $3,000 good bond. No further contact with Ms. Oliver. Stay away from the incident location. No drugs, alcohol, weapons while out on bond. Your client has his hand up, Mr. McLean.
He can call me at 5215. It's part of the county extension 2-5215.
What was that bond?
$3,000 good. Courtroom 2.
Yes, we got number 15, Mr. Stallings. Excuse me, who I talked to about it?
Good afternoon, Mr. Stallings. You've been charged in case 25 CR 001548F with criminal trespass. Is there a history, Mr. Howard?
29. 2022 simple assault conviction. Probation violations from 2019, 16, and 15. 2013 terrorist threats, possession of marijuana conviction. Homeless.
Dunlap.
Thank you, Your Honor. This incident date happened on March 24, 2025 at 190 Marietta Street Northwest in Atlanta. Officers arrived on the scene and spoke to the security guard, who stated the defendant had been previously warned and cited for criminal trespassing. Defendant was on the side of the building covered in a blanket, was detained by officers. A previous warning was issued on March 21st, 2025. The state is looking for a signature bond through the jail and a stay away from 190 Marietta Street Northwest. No drugs, alcohol, or weapons while on bond.
Take it, no objection, Mr. McLean.
No objection, Your Honor. I would like I'd like to ask Mr. Stallings to come by our office and speak with our social worker. I've already contacted our social worker about giving him some advice on housing. So if he could possibly come by 100 Peachtree Street, 16th floor, as soon as he can, we'll try to help him out. But we have no objection to the signature bond. Thank you.
Be $1,000 signature bond through the jail. Stay away from the Marietta Street address. No drugs, alcohol, weapons while out on bond, and the assistance of a social worker. Good luck to you, Mr. Stallings. Courtroom 2, you all able to find out about Mr. Ferguson?
So that he's gonna be a reset. Intake butt naked. What hurt?
So it's gonna be taking a medical reset?
Yes, sir.
Okay, so we'll reset Mr. Ferguson until tomorrow, 3/26. That should give you enough time to speak with him, Mr. Sally.
You're on mute, sir. Your Honor, just to make the record clear, this is the second reset. And so at this point, the state does not believe this is a Riverside issue.
Okay. Given that it's a medical reset, Ms. Sally, I understand. What you were saying, Mr. Sally, while you were on mute?
I was just saying I appreciate it. I'm going to see what I can do to get in touch with him tomorrow.
Okay,
Or before the hearing tomorrow, for sure.
Okay, if you can't get him before us tomorrow, if you can possibly get him to waive his appearance so that we can move this on, we'd appreciate it, okay?
Yes, Judge, of course.
Okay, very good. You have a good rest of your day.
Thank you, Judge. Likewise.
Thank you. Okay, everyone, I believe that covers, did we get everybody?
Yeah.
Okay. All right, Ms. Bridgewater.
Okay, once again, the reset date for the SAP calendar is April the 8th. Position number 1 is going to the SAP calendar with a $2,500 good bond. Position 2 is reset further notice with a $2,000 SOB through pretrial. Position 3, reset further notice with a $1,000 SOB through pretrial. Position 4 is reset further notice with a total $4,000 SOB through pretrial. Position 5 is reset further notice with a $1,500 SOB through pretrial per judge. Position 6 is going to the SAP calendar with a $1,000 good bond. 7 is being medically reset till tomorrow. 8 is reset further notice with a total $4,000 SOB through pretrial. 9 is going to the SAP calendar with a total $6,500 good bond. 10 is going to the SAP calendar with a total $2,000 good bond. Position 11 is reset further notice with a $2,000 SOB through pretrial. Position 12 is going to the SAP calendar with a total $3,000 good bond. 13, reset further notice with a total $1,000 SOB through pretrial. 14, reset further notice with a $3,000 SOB through pretrial. 15 is reset further notice with a $1,000 SOB through the jail. And for the add-on, it is going to the SAP calendar with a total $1,000 good bond. Are there any questions, comments, or otherwise?
It's contact for number 5.
Number 5's contact will be, let me get to it. No further contact with Frank Morris.
And what was that amount?
I have $1,500 SOB through pretrial.
Okay.
Are there any others?
Yes. McLean, Mike represented number 15, right?
Let me see, I can tell you.
Or Mike, did you represent?
That is correct.
Okay. That's correct.
Let me grab number 15 is
Willie Stallings.
Yeah, I've got him. Yeah. Willie Stallings was 15. I did.
And then you said on number 12, Melvin Merton, that's going to be a $2,000 signature bond? Is that just how that
For
right?
number 12, I have it as a total $3,000 good bond.
3,000 good. Okay.
Right.
3,000 good. Got it.
Are there any others?
I think that's all, but just let me just double check, make sure nothing else is highlighted on my calendar. Nope, that's all for me.
Okay.
Thank
Hey,
you.
y'all. Have a good rest of your day.
Are we gonna get you tomorrow, Judge?
No, I'll be back on Thursday though. So I'll
Okay.
see y'all on Thursday.
Well, have a good night. Thank you,
All right.
everyone.
All right,
Have a
take
good
care,
one.
everyone.
All
Bye-bye.
right.
Bye-bye.
I'll get it back to you as soon as I get it, Miss Bridgewater.
No problem, Judge. Coming to you.
All right.
You look tired. I'm gonna get it back to you real soon.
I had a rough I had a rough SAP this morning.
Oh, wow. Okay, here it comes, okay?